Hi, good evening, everyone. Can we have everyone seated, please? Uh, Sorry if I may be sounding a little rushed because though this is technically a speaker's dinner, we've had many requests over the past 2 years. Why aren't participants invited? Why aren't we live streaming? So this year we have about a couple of hundred people waiting in the queue to be admitted, which they are being admitted for a 7:30 session. We are almost 20 minutes late. We did anticipate that we will be 15 minutes late. So let's get started. Ladies and gentlemen, friends, esteemed guests, in my capacity as a trustee and conference director and on behalf of the foundation, I'm pleased to welcome you all for the pre-conference speakers dinner. Even to headline the 30th edition of our annual conference is a task, but let me see how I fulfill it, particularly given the fact that we had many people who could not travel to Mumbai because of flight disruptions in the last few days. Much like the earlier editions, we will kickstart our discussions and intellectual pursuits with a theme that is not just imperative but enriching for today evening. Honorable Justice A.K. Sikri, I would not take a whole lot of time in setting out the theme tonight, but when I met with him a couple of months back and we were trying to debate which topic he would speak the most, he asked me, what's your view? And I said, sir, nexus is a very important topic in international tax. Though as a jurist, he's authored many decisions, and he immediately developed a better theme, which is nexus and its far-reaching implication on the international tax policy after he looked to what was the draft agenda at that point in time. I also wanted to thank the scientific committee who applied their mind and looked at this topic in a much more holistic manner. Well, friends, as cross-border commerce transcends and goes beyond the bricks and mortar economy, Indian courts and policy makers, and some of them we have over here, Dr. Tanwani, thank you very much for coming, a senior IRS official who I had the opportunity to argue a matter before. 4 days he kept me on my feet before the Advanced Ruling Authority. The Indian courts and policymakers have started to recognize the value that could be generated within the corporeal footprint. Jurisprudence has gradually evolved, and Supreme Court and High Courts are not behind, looking at the principle of nexus, in a way calling it as presence beyond and presence of the economic participation. This conceptual shift has resulted in many changes in the policies and legislation, and we've seen equalization levy, which now stands abolished, but more importantly, the definition of significant economic presence very much in the income tax statute. The Indian experience reflects both fidelity to foundational principles and a willingness to boldly reinterpret them, forging a nuanced framework that seeks to balance sovereign taxing rights with fairness, predictability, and international coherence. These three are not very easy objectives to meet. For the taxpayers, fairness is important, predictability is important. For the sovereign government, protecting the sovereign interest, including taxing rights, is critical, and hence the task is left to the courts. But equally, how does India integrate with global policy is critical. And hence the nexus principle in its modern incarnation must evolve from a mere jurisprudential threshold to a sophisticated, equitable instrument capable of capturing the real economic value, or what the OECD calls it as value creation. It must serve, in our view, in Foundation's view, not only as a doctrinal compass for states seeking to assert legitimate taxing rights, but also as a moral character that safeguards against the shifting sands of base erosion, profit migration, and regulatory arbitrage, including respect for double tax treaties. From a tax policy perspective, it must harmonize divergent national interests through a shared vision, one that balances sovereignty with solidarity, efficiency and fairness, and innovation with accountability. It is at this juncture that our guest, Honorable Justice A.K. Sikri, views and will share his insights, even from a jurisprudential standpoint, to understand and appreciate these developments. Justice Sikri has a BCom honors from the University of Delhi and has 2 postgraduate diplomas in company law and administrative law from the Indian Law Institute. He topped the LLB exams in the Delhi faculty in 1977, completed his LLM in 1980. In those days, LLM was 3 years, just to clarify. Now you can get LLM in 1 year. So 1980, he started practice in the Delhi High Court in 1977 and handled all types of cases with specialization in arbitration, commercial, labor, and constitutional matters. In 97, he was designated as a senior advocate by the Delhi High Court, and in 99, he became a judge at the Delhi High Court. In 2011, he also served as the acting Chief Justice in the Delhi High Court. I had the privilege and honor to appear. Sir may not remember, but in terms of fairness, there was a matter on which we were being led by 2 senior advocates. It was a matter on permanent establishment. We lost the matter. We filed a review petition. The matter was then divided in 2 classes. One review petition, the same senior advocate appeared. It was rejected. Second time when the matter came up, the senior advocate told me, Mukesh, there is no use. You go and argue. I stood up very nervous in the court. I was in the bar only for 1 year in 2011. You may remember that. He heard me patiently. It's one of those few judgments where he recalled the matter because there was a mistake which he in his wisdom believed was apparent from the record. Most people read Rolls-Royce PLC, judgment of Delhi High Court. They don't read Rolls-Royce Singapore, particularly the recall judgment. It's one of those few recall judgments which is also quoted, not as often as it should be, but it is a judgment that was listed in many, many cases. It's one of those few judgments where mostly when judgments are recalled, they are not quoted in the law books, but this judgment was quoted, and perhaps that's a permission Justice Sikri would have granted. Well, he was elevated as the Chief Justice of Punjab and Haryana High Court in April 2013 and later on appointed to the Supreme Court in the same year itself. He superannuated in March 2019 as the senior most judge. He has authored over 4,700 judgments in different fields of law. First time unprecedented, Supreme Court had a dedicated tax bench. After a while, it was regarded as Justice Sikri and Justice Nariman's tax bench. Several hundreds of cases. This was a dream time for tax lawyers in the Supreme Court, which lasted only for 15 months. After that, there is a dedicated bench, but not the dedicated bench that we had seen when he was occupying the chair. Well, he has been chosen as one of the 50 most influential persons in the world who impacted the growth of intellectual property laws for the year 2007. Currently, he serves as a judge of the Singapore International Commercial Court. He is also the chairman of National Court Management Systems Committee, chairperson of the Committee for Formulating Action Plan on Online Dispute Resolution under Niti Aayog, which is chaired by the Prime Minister, Government of India. He is the chairman of the News Broadcasting Standards Authority, chairperson of the Interim Advisory Council, Delhi School of Public Policy and Governance, University of Delhi, and an ombudsman of Federation of Indian Fantasy Sports. He is also the visiting professor of various law universities. It is my privilege to welcome Honorable Mr. Justice A.K. Sikri as a keynote speaker tonight, a visionary thinker, a stalwart of justice, and a voice of measured authority. We are truly fortunate to have him guide us through the contours of next principle. Over to you, Justice Sikri. The floor is yours. Thank you.
Thank you. Thank you, Mr. Mukesh Bhutani, for your generous introduction. That makes my task still more tough. I don't know. Uh, if I may say, yes, I had the privilege of sitting in the High Court on tax bench for a number of years. Even in the Supreme Court, almost entire tenure, tax matters were assigned to me. And what I feel is that whatever I have learned, even in the capacity of his judge, insofar as tax laws are concerned, it is because of you people who are sitting here, because it is the advocates who argue and make us wiser, as you made me wiser in that particular case, and I recalled my judgment. I was just wondering that it's just role reversal today. You are all very, very accomplished advocates in tax law who have been arguing before the different courts of different countries, before the judges, and here is a judge who is now going to argue before this august gathering. I don't know whether I'll succeed in my case or not, and what kind of verdict I'll receive at the end of my speech or my arguments. But thanks, Mr. Mukesh Bhutani, and thanks FIT for inviting me and organizing this special lecture. Another challenge is, if I may say so, it's dinner time, and so you are all must be waiting to have your dinner, but you will still have to bother or bear with me for some time, which is assigned to me. And it is like arguing before the court when it is lunch time and judges are not allowed to rise for the lunch and are forced to hear the arguments. The topic, as Mukesh has already informed, when we saw this theme of this this conference on the evolutionary corridors of tax policy and certainty. Of course, the idea came from Mr. Mukesh Bhutani only on nexus, which is one of the most important aspects of the tax policies, and particularly when it comes to taxing the non-residents. And so therefore, but then I refined it for some time, I mean in some way, and here I am. If I may say so, Mr. Bhutani has already, in his brief introduction on 2 or 3 minutes on this topic, has actually summed up and has even given his judgment insofar as this topic is concerned. Yes, fairness, predictability and sovereign power, and how these can be balanced. And that becomes one of the most important aspect of this nexus principle. We have the habit as judges, when we write the judgment, we start from introduction and say something. So in the beginning, if I am saying some of the aspects which are very well known to you, of course, what I will say later also, you would be knowing, most of you, but then please bear with me as I develop my lecture on that theme. As I see, economists, jurists, lawmakers and sociologists across the world have made interesting remarks on the sovereign power of the state to impose taxes on its subjects. If on the one hand, the imposition of taxes is justified on the ground that taxes are the price we pay for civilized society, the other extreme view is that the power to tax involves the power to destroy, and most of the people are not happy. Notwithstanding, it is widely accepted that taxes are the lifeblood of a modern economy, and therefore they are here to stay. And as they turn individual contributions into collective strength, enabling a country to grow, protect its citizens and stay resilient. Thus, it should be an endeavor of any state with good governance to create a tax regime which is respectable, which is respected by not only the people of the country, but I mean others as well. It is described best by Nani Palkiwala, one of the great jurists, and who was, I think, the income tax law was his forte. Of course, he turned out to be a great constitutional lawyer also. In 60s and 70s, most of the constitutional landmark judgments, if you see, he would have appeared. And he's one of the most respected lawyers India produced in post independence era. So, if I quote him, he says, taxes are the lifeblood of any government, but it cannot be overemphasized that the blood is taken from the arteries of the taxpayers, and therefore, the transfusion has to be accomplished in accordance with the principles of justice and fair play. I think that sums up the entire tax philosophy and how the tax policies should be adopted or made. The fairness has to be seen from the prism of, if I may say so, as to income which is going to be taxed, at what rate it is going to be taxed, and who are the persons at whose hands the income can be taxed. A principle which is uniformly recognized all over the world is that state can tax the income which is earned or accrued within the geographical boundaries of that nation. Therefore, those persons who make earning in a country may be taxed for the income they have earned. The income tax law embodies the concept of residents and non-residents in contradistinction to citizens and non-citizens. Thus, even a non-citizen who is a resident, say for example in India, and it is the position elsewhere as well, is supposed to pay taxes on the income which he has earned in that capacity. The Indian income tax law, like most laws in other countries, makes the income of non-resident as well taxable if it is earned or accrued in India. Section 5 of the Income Tax Act defines the scope of total income and distinguishes between the tax bases of residents and non-residents. For residents, worldwide income may be taxed. For non-residents, only income accruing, arising or deeming to accrue or arise in India is covered. Section 6 prescribes residence test for individuals and companies. It thus creates a personal nexus enabling India to tax global income even without territorial elements. It may be treated as facet of international taxation. Theoretically, it may sound simple, but as we see and in real time, because of the complexity of global businesses and global activities, it poses various challenges. Why I say so? And we are here now discussing about the income of non-residents which is taxed in a particular country. And this principle of nexus, or what Section 5 captures in our Indian Income Tax Act also, I mean, may seem to be very simple, but in real time it may create difficulties. And one of the reasons is, if I may say so, rapid expansion of globalization, which has enabled goods, services, capital, technology and human resources to move seamlessly across national boundaries. The resulting deep economic integration has been characterized by, among other things, increased flow of foreign direct investment, FDI as we call, cross-border licensing and transfer of intellectual property, mobility of skilled professionals and the rise of digitally delivered business models. The development coupled with rapid technologies, it make it difficult to ascertain whether income has accrued in a particular jurisdiction, even when the person or the entity has its physical presence in some other jurisdiction. These developments have created legitimate expectations of uniformity and predictability in legal outcomes for individuals and multinational enterprises operating across jurisdictions. States correspondingly begin harmonizing domestic laws with international standards to reduce friction in cross-border commerce. And uh, therefore, in this context, if I may say that two I mean aspects which Mr. Mukesh Bhutani has also alluded to, apart from the power of the any sovereign state to tax, but then the balance where it is to be maintained is that a person who he may be a non-resident but tax for income in a particular jurisdiction should not pay tax again in his own jurisdiction on that very income. So there should not be double taxation. And on that we know that there are double taxation avoidance agreements which are signed. That is one. And on the other hand, a state also wants that income which is taxable should not go away, and the state exercising its sovereign power is able to tax that income. And therefore, in these circumstances, then how to balance the sovereign right to tax with imperative to avoid double taxation and at the same time preventing erosion of tax base. And for that, as we know, that general anti-avoidance rules, GAR, or double taxation avoidance agreement, DTAA, etc., have come into force, and at multilateral level, OECD advanced these efforts through model tax convention and income and capital, which offered a structured basis for regulating cross-border taxation. So, a universal principle which has emerged is that the international taxation rests on foundational principles that a state may exercise taxing rights over cross-border income only when sufficient territorial, economic or personal connection links that income to the jurisdiction. So, this test, which is widely described as the nexus requirement, is a constitutional and public international law concept that restricts extraterritorial assertions of fiscal authority. And therefore, keeping in mind this text and this today's theme, I have structured this lecture. And in this, if I may say so, I have said, divided it in 4 parts. In part 1, I would state in brief the relevant provisions of Indian Income Tax Act, which are aligned with OECD and UN models incorporating nexus principle. The nexus is traced to what is known as permanent establishment in India, as we will see. So therefore, in part 2, I shall narrate the legal position pertaining to permanent establishment and its function as a nexus. Then thereafter, part 3 discusses some of the landmark judgments rendered by Indian judiciary on permanent establishment and developing the nexus theory in the process. Though the income tax laws in most of the countries are founded on OECD and UN models to achieve cross-border uniformity, notwithstanding this textual foundation, we know that judiciary in different countries have given different interpretation and have adopted different tests across the jurisdiction. Therefore, in my concluding part, I will deliberate on the question as to whether there is an ideal tax nexus and whether we can achieve it as a policy. So, coming to nexus principle in Indian law in my part 1. I have already alluded to provisions of section 5 and 6, so don't want to repeat that. To this, I only add that section 9 operates as India's statutory source rule. It deems that the income to accrue or arise in India when it arises through or from any business connection. It uses the expression business connection. Explanation 2 clarifies that a business connection includes activities of persons who habitually conclude contracts and maintain stock for delivery on behalf of the non-resident. Explanation 2a, inserted to respond to digital business models, establishes another interesting principle, which is called significant economic presence, SEP, through revenue linked and user linked threshold. This is described as a legislative attempt to move beyond physical presence and recognize digital economic participation as a valid jurisdictional basis. The equalization levy, introduced in 2016 and expanded in 2020 and now abolished, it reflected India's reliance on unilateral digital nexus rules, distinct from those under the Income Tax Act. But what is important is, apart from these sections 5, 6 and 9, which normally incorporate, as I have said, this business connection or significant economic presence, we have very important section, that is section 90. And what it says, when a tax treaty applies, section 90 gives the convention an overriding effect. So therefore, if there is a tax treaty which is based on OECD or UN principles, and if that applies, if that is signed with any country, then it is that tax treaty which would apply, and that has made a lot of difference insofar as judicial interpretation of permanent establishment in India is concerned, to which I will allude to soon. So under Article 7 of both OEC and UN models, business profits of a non-resident may be taxed in the source state only if the enterprise maintains a permanent establishment. PE therefore becomes the threshold for treaty level nexus. So therefore, we depart from business connection, which is mentioned in section 6, and when there is a treaty, we come to another totally different threshold for the purpose of nexus, and from business connection, it is now permanent establishment, because that is what Article 7 of OECD or UN models, they describe that. And it is in this connection that we have to understand the two-tier nexus system in India, the domestic rule governing chargeability and the treaty rule governing enforceability, if I put it in these words. And PE seeks to balance two competing considerations. Source states seek to tax non-residents who derive significant value from the market, while resident states attempt to prevent overt extension of source jurisdiction. So in this context, I may also refer to Article 5 of OECD and UN model conventions, which define PE as a, now what is the definition that is given in this? First, fixed place of business through which the business of an enterprise is wholly or partly carried on. So fixed place of business through which business of an enterprise is wholly or partly carried on. So this definition incorporates three core requirements. Number one, there must be a place of business. Number two, it must possess a degree of permanence. And number three, the enterprise must carry on business through that place. The UN model extends the concept to service-based presence and dependent agent activity also. So therefore, and the treaties also recognize several categories of PE, if I may say. It is fixed place PE, which covers offices, branches, factories, workshops, etc. Construction PE, which deals with building sites, installation projects, or supervisory activities connected to such sites. And agency PE, which captures situations when a person in source state habitually concludes contracts or plays the principal role leading to the conclusion of contracts. And service PE under the UN model, which I just now referred to, which brings in service activities performed within the source state for specified duration. So they're going by these principles, and whenever the treaty applies, how the Indian courts have dealt with that. So let me come to that part now. Much before this, all this started happening, we have one judgment of 1965 when this regime was not there, but then that becomes somewhat important to understand the further progress in this direction. And the judgment of the Supreme Court, it was in this, it examined the contours of territorial nexus. And the case is CIT versus, that is CIT means Commissioner of Income Tax versus R.D. Agrawal. The court explained that business connection, at that time it was only section 6, so therefore business connection was explained, requires an element of continuity between the business carried on abroad and activities carried out in India, which contribute to earning of income. The court observed that the connection must not be a stray or isolated transaction. It became very helpful in ultimately deciding the concept of permanent establishment, and that is why I am referring to this. So the court observed that the connection must not be stray or isolated transaction, but must demonstrate a real and intimate relation between the activities in India and the business of non-resident. Although, as I said, the case predated modern treaty language, its emphasis on relationship intensity laid part of the conceptual foundation for later PE doctrine. And the another case, of course, it is now post-treaty, that is GVK Industries Limited versus ITO, that is Income Tax Officer, which was decided in 2011. The Supreme Court reinforced that India cannot legislate extraterritorially without a real territorial nexus. It was where the law was challenged, and the Supreme Court said, sorry, the Indian Parliament has no power to pass such a law, thereby taxing the income or extraterritorial jurisdiction you don't have. Therefore, unless nexus is established, you cannot tax a particular income. And but insofar as PE is concerned, permanent establishment, it if I may say so, it began to crystallize with very, very well-known judgment, which is oft quoted. I think if we go online and search, it must have been quoted subsequently in 100, 200 judgments also. This is Ishikawa-Jama, Harima Heavy Industries versus DIT. It was in 2007, where the court analyzed whether the offshore supply of equipment and related services constituted business income taxable in India. So it was supply of equipment, offshore supply, and related services. The court held that offshore supply could not be taxed unless PE in India was involved and the income was attributable to it. And the court found that the segregation, it emphasized that the segregation of supply and services and rejected attribution that lacked a real territorial connection. The judgment clarified that treaty provisions override domestic law. This is very important, and that is what I said in the beginning. That was clarified in the judgment. The judgment that treaty provisions override domestic law under section 90, and also differentiated between business connection and PE. And the other judgment of the Supreme Court came sometime in 2017. I'm only referring to some of the more important judgments because there's so much plethora of case law, including at the level of Income Tax Appellate Tribunal and High Court also. But maybe some judgments of ITAT I would refer to. But time doesn't permit to say all these judgments. But yes, the judgments which I am referring to will, bring forth the concept which I am trying to develop, or the message which I am trying to give. So this judgment is Formula 1 World Championship Limited versus CIP. It was in 2017. And in this court, in this case, the court held that Formula 1 which had organized in India an event, Formula 1 event, and the question was whether it is taxable income or not, or whether it's a permanent establishment or not. The court held that Formula 1 had a fixed place, PE, in India during the Grand Prix session. The court explained that the Buddh International Circuit, where the race took place, the place of business, was at the disposal of FOWC during the event period and was used to carry on core income generating activities. The court rejected the argument that temporary control cannot constitute a PE. It further held that what matters is the nature of rights exercised, not ownership or long-term possession. And so three things which was emphasized was, one was the disposal test, that is whether the premises or that particular place to constitute PE was put at the disposal of FOWC also or not. The answer was in the affirmative. The second was this permanence, that is this concept of permanence was explained in stating that it does not require an unlimited or long-term presence, but only stability sufficient for carrying on business. And the third was through test, that is, which requires the business must be carried on through a particular location which is at the disposal of the enterprise for that purpose. And the court held that all three requirements were satisfied, and therefore it would be a permanent establishment, and the income generated by Formula 1 from that activity in India, which was physically carried out in India, the income was taxable. And but just in contrast, in 2017, another judgment which is ADIT versus eFunds IT Solutions, and here the court held that mere outsourcing of back office and support functions to an Indian subsidiary does not create PE. So this is how the tests were applied, same test, and this Formula 1 tests which were established in that judgment are recently, in this year only, the court has reiterated in Hayat International case. And in this case, the court analyzed whether Hayat International, a UAE resident entity, had created a fixed place PE in India through its long-term strategic oversight service agreements with Indian hotel owners. The court held that degree of operational, and this was found as a fact, degree of operational and managerial control granted to HI under SOSA, including authority over the recruitment of key personnel, operation policies, reservations, pricing, and compliance with global brand standards, effectively placed the Indian hotel premises at the disposal of foreign enterprise, therefore thereby establishing a fixed PE. So these, if I may say so, that this is today the jurisprudence which relates to PE in India. But I should here spend few minutes on another aspect, that is the challenges which modern technology is bringing in determining the PE. This is the digital business. So digital business models have challenged the classical requirement of physical presence, and in determining whether PE exists or not. And three aspects, if I may say, I may highlight. In the first place, that there is debate around the issue as to whether business, servers, data centers, or websites can constitute a place of business. Interestingly, the judicial approaches in different countries vary. For example, Singapore courts have treated servers as fixed place of business, but in India, ITAT, Income Tax Appellate Tribunal, Kolkata, has declined to treat websites as the place of business. So although virtual PE concepts have been contemplated by some jurisdiction and discussed in OECD's 2018 interim report, Indian tribunals have explicitly rejected this interpretation for time being, for the benefit of non-residents. And this is the view taken by, in the last year, 2024 only, by Delhi Income Tax Appellate Tribunal as well. And the second aspect is just to, I am only highlighting here the OECD's 2025 update, which has introduced explicit discussion on home office PE, recognizing that remote work arrangements may satisfy the disposal and permanence test when those spaces are at the disposal of the enterprise and used for core business functions. Let us see when Indian courts start adopting this particular update and start holding in such cases that the PE would be, it would constitute PE in India. And third aspect I have already mentioned, although is explanation 2A of section 9, that is significant economic presence. Now this is the concept which is introduced in India, and for time it is in India, but then it is so far has not been able to be utilized much because of section 90, to which I refer to. And whenever there is an international treaty, So the Indian law would give way to international treaty. So instead of applying therefore in many cases SCP principle, it is the PE principle which is applied, and the income is treated as non-taxable as of now. So that is the position insofar as permanent establishment is concerned. There are few judgments, other judgments also insofar as digital, this through digital technology business is done. I am just keeping that. I have referred to two ITAT judgments. So with this, if I may just say here for a few minutes that some of the updates, one I have mentioned about the OECD 2025, but then the base erosion and profit sharing shifting BEPS project developed by OECD and G20, and here BEPS Action 7 addresses the artificial avoidance of PE by expanding the dependent agent rule, and it also introduces an anti-fragmentation rule. Then there's a multilateral instrument which enables jurisdiction to implement these PE related treaty changes, and at domestic level India continues to articulate its policy stance through mechanism aligned with BEPS principle, and Niti Aayog's 2025 discussion paper proposes a formula, that is Niti Aayog is our think tank of India, which is sort of planning commission, which is now re-christened as Niti Aayog. It has proposed a formula, the paper they have come out with discussion paper, which has proposed a formula based approach to profit attributing using sales, manpower and assets as indicators of economic engagement. So these are totally new concepts which may be, but this is only a discussion paper, and on the basis of discussion whether any law is passed tomorrow or not will have to be, we'll have to wait to see it. Now, as I said earlier, this is the position in Indian law, but then in many other jurisdiction position doesn't remain the same. Although most of these provisions are based on OECD and UN model treaties, and many countries have adopted that, but the judicial approach may be different. So therefore, in this context or in this background, is there an ideal tax nexus? That is what could be the policy, and what is whether there is an ideal tax nexus, and whether we can have this concept. And I will say something about it in my address. So first is, what is the concept of ideal tax? It is inherently contested. The concept itself is inherently contested because jurisdiction of tax reflects fiscal sovereignty. So therefore, when it becomes a matter of sovereignty, different countries will exercise the powers, sovereign power in a different way. So achieving a uniformity itself becomes a challenge in this context. So states design nexus rules to secure revenue from cross-border activity, protect domestic tax bases, and advance preferences regarding the distribution of taxing rights between residence and source jurisdiction. So, and from a theoretical perspective, three sovereign motives can be understood to be the part of evolution of nexus rule. First is a sovereign or a fiscal protective motive. Secondly, a coordination motive, and thirdly, a distributive motive, to which I have referred to. But ultimately, the attempt has to be, when we talk of international taxation, and as in the beginning, Mr. Mukesh Bhutani also mentioned about the fairness, predictability, which are very, very important and core, although at the same time retaining this sovereign power. So how we achieve that is a challenge, and so reasonable. And one thing which is talked about is that if we see it or looked at from the prism of reasonableness, and another concept which is introduced, and I was really, when I was looking into it, I was amazed to see that, because that we have used in India, and many other countries have also used, and I can take some pride in this, that in one of the constitution bench judgment which was authored by me, in 2017, 18 maybe. So we brought that, which is called the doctrine of proportionality. And that doctrine of proportionality normally under the constitutional law is used to see whether a particular law enacted by the parliament or state legislature is constitutional, and to judge the constitutional validity, to tell my foreign friends that in India we have the power, judicial review extends not only to executive power, that the executive function or the particular act of the executive which is challenged, and we can see, but it extends to the this legislative power also. So Indian Supreme Court and even the High Courts have the power to strike down a particular legislation passed by the legislature if it doesn't pass the muster of our constitution. We say constitution is supreme. So no law should offend any of the provisions of the constitution. So therefore, when this is, constitutionality of a provision is to be seen, and in that case it was Aadhaar judgment, if I may say so, where we said that some of the provision, yes, on the one hand, and the issue arises where there is a conflict. On the one hand, public purpose which is to be served, which may have some aspects of fundamental rights in our constitution. On the other hand, privacy, as in that case, was treated as again another fundamental right. And if there is a conflict between these two rights, if somebody says my right to privacy in Aadhaar, as I'm saying, is violated, but on the other hand, the law is passed to subserve another fundamental right, and that the conflict arises, how to resolve that. And there we introduced for the first time in India, I won't say that I am the person who originated that. It was, I think, German and Canada had already, which I studied, and then introduced that doctrine of proportionality should be there. And doctrine of proportionality, it's a three-tier this test which is applied. First is the nature, purpose, and aims of the fiscal instrument. In the context of taxation, I am now coming. So what is the nature, purpose, and aims of fiscal instrument? Secondly, the extent and impact of nexus rule. And thirdly, the coherence between the tax goals and the degree of interference imposed. This is what, and fourth, whether I will say, whether less restrictive means exist to fulfill these goals. And this fourth is very, very important. You are achieving this, whether there are other less restrictive. As I said, in constitutional law, if some limitation is imposed on the human right or any fundamental right, whether there is any other method by which you can achieve. If you can, then you cannot intrude into the rights of the person, and the law is declared ultra vires. So same test, this is explained by Hetting and Hon'ble, as you may be knowing, and they have said that proportionality and fair taxation, a very nice paper written on that. And I think if this is introduced along with the fairness, and the some tests are introduced on this basis, maybe we may be able to achieve some better results, or we may able to get some ideal nexus principles. Thank you very much.
Well, what can I say? It's been extremely inspiring lecture. Thank you very much. I know in one brush you covered. For those of you who don't know, some of you may not know, Justice Sikri authored the Formula 1 judgment when he was in the Supreme Court. Hakim whispered to me in my ears that every word that was said in the concluding part in relation to the nexus principle, he could actually translate it into the German language, because the German courts have apparently taken the view that you articulated on the principles. If there are any questions, we'd be very happy to take them.
Let them have their dinner now.
Let them have them. Okay, so on that note, I think we are just on time for dinner. The dinner is being served on the other side. I had the executive chef. He wanted to give some description about how he has curated the dinner tonight. He's not around, but this is a Maharashtrian thali. We are in the state of Maharashtra, and this is traditional Maharashtrian food. He will probably come and share his views. So with that, we end the session of the lecture today. Thank you very much for joining us. But for everyone, please join us for dinner. Pick up your drinks. The drinks are going to be served in that side of the room as well. But thank you very much, and I look forward to welcoming you all tomorrow as we kick off the session. Thank you very much, and good evening to everyone.